You have reached the voicemail for Kathleen, Administrative Assistant to Alan Lanning, and Sam Harris. To reach Sam Harris, please email him or call his direct extension, which is 727-9273. Again, 727-9273, and leave a message. If you need to reach Alan, please leave a message with me or on his direct.
Please state your name after the tone, and Google Voice will try to connect you.
Sam Harris.
This is Sam.
Hi, Sam. This is Jason Masick. I got your number from the county public defender's office. They said you were.
Yes.
They said you were assigned to my case. I've been trying to get that information since the 18th of April. They just now notified me, and I have a hearing tomorrow.
I was assigned yesterday, so.
Okay, perfect.
Yep.
Then
Yeah.
I have an omnibus.
To take some notes.
Sorry.
I know. Hold on. Let me catch up.
Okay.
Okay. What's your phone number?
406-403-1404.
All right. And email address?
Jason.masick9779@gmail.com.
Jason.masick979
9779.
9779. Okay, got it. All right, I'm aware that there's a hearing right away. I have not had opportunity to see what documents they're able to get me. All I have is email, indicating that you've got the case, and I think maybe the order setting trial might be the only document that I've seen. So I will get with those things as quickly as I'm able. As quickly as I'm able is likely 9 o'clock tonight. There's not going to be any particular proceedings that go forward under that circumstance to your detriment. But part of the reason they gave that to me was with the timing of that assignment is somebody's going to hit the ground running, and I can do that. But I've got other obligations for the rest of today, and actually no internet service for at least until later tonight. So I'll get going on that. The basic allegations here are just kind of running your mouth. There
Yeah.
needs to be none of that while this is pending, right?
Okay.
Yeah, because you don't want this getting deeper.
Okay.
So, do you have any questions for me?
I do. I want off this house arrest because there's no reason for me to be on it.
What house arrest?
They have me on house arrest for no reason. I mean, defamation of character doesn't, I think, warrant house arrest.
Okay, well, hold on. Are you on actual house arrest? You're confined to your house?
Whatever the ankle bracelet monitor is, I consider it house arrest because I can't do anything while it's on. I can't go train for competitions or anything.
An ankle monitor would be a GPS monitor. That's not house arrest.
Okay, well, we can call it whatever we want it, but GPS monitor it is then. I would like to get off of that because there's no reason for me to be on it.
Well, what we can do if have you had a bail hearing? Have you had a hearing on that issue?
I haven't had anything on anything because I haven't had any kind of contact from anybody.
Okay. Let me make a note of that.
This is the first time I've talked to any counsel.
Okay, and that's okay. We'll get caught up there.
Okay. And I'm autistic. I want that just so you know. It's not diagnosed.
Oh, I appreciate that.
But I just have volume levels, so if I get loud, I apologize that, and quiet, I have problems with just volume levels. So
Okay.
just a
Well, I can work with that.
Okay.
I'm not offended by if we have strong talk and that kind of thing, and I'll work within your means to communicate in a way that's effective for you.
Okay.
With regard to, I gotta get my truck started and let my phone connect. 1 second.
Sure.
Oh, truck. Okay, can you hear me?
Yes.
Okay, good. I just wanted to, I've got to get moving. I just got out of a hearing and have to be on the move here.
Okay.
With regard to bail conditions, you are entitled to a bail hearing on that issue, so that's the process. And so I can request that and we can have that. I would say from the nature of the allegations, you're probably going to stay on that GPS. And I understand from a subjective perspective that you don't think that there's an issue there, but I represent a lot of people in circumstances like this. I actually have a very significant one going on right now. I've had others, and whether you recognize it or not, the nature of statements like that with public officials can be very concerning, and the line between threatening and not threatening gets very thin. And so from the perspective of the person that's maybe in control of the speech and all of that, you know your intentions. Other people don't. And so whether it was your intention or not, your statements appear to be kind of extreme. And so then they put you on the GPS monitor as a protective issue.
How is that protective, though?
So you can have a hearing. Well, it keeps track of where you are. They can tell if you're around. I believe Judge Parker was the intended target of the speech.
Well, the speech is these signs have been up for over 2 years. Anybody that's driven around Great Falls knows it. So I mean, the lack of issues for the last 2 years on these signs is just going to be evidence showing the jury that this is an issue that really isn't a character defamation case. This is politics, and he doesn't like the politics. So that's why this is going to jury trial. But then there's no reason for me to be on an
it can go to, but hold on. You can't state things as conclusion and fact with opinion language.
Okay.
That's not an effective way to communicate about facts and circumstances.
No, and that's why I have all the facts.
You do get trial, but
right.
You do get trial, but understand that your perception of those things, of calling it just politics, that's a real broad sweeping thing. Can we say just absolutely anything and it's just politics?
Well, I can back mine up.
You can't say absolutely anything.
But I can when I can back it up with my own cases and other cases. I didn't say anything that's not provable.
Sure, understand that the information that I have is limited, and so I'm not making any final judgments or conclusions.
Right.
Because I've not even seen the law enforcement reports. I don't pretend that I know everything, but I will tell you, I've done this for 25 years. I work twice as many hours as anybody else. I have 50 years of experience doing this shit. And so I can read between the lines on a lot of stuff and at least get some preliminary ideas.
Good, because I need the best.
When we talk about one of the things that I see in there is that it appears that some of the allegations are that the signs say things like child predator.
Okay.
Now, being able to, quote, back that up.
I can.
I'll have to hear what well, and maybe you can.
I can. I can prove it, document it.
That's a pretty broad sweep.
Because at this point, me being on this ankle bracelet, I consider it him being a predator after my children's money, because it's costing them money. It's not costing me money. I have to borrow money.
But that's what I mean by using conclusion type words. That's almost a ludicrous statement. That does not have any logic to it.
But it does.
A bail condition imposed by a different judge does not make Judge Parker a predator. That's not logical. Those two things aren't connected in that fashion.
Okay, but isn't that your job to get it connected? As a lawyer?
No,
As my
job
lawyer?
is not to somehow. No. When something isn't logically connected, there is nothing that an attorney can do to quote connect it.
But because you can't logically, hold on, because you can't logically connect it. I can logically connect it. I get to logically connect it. And I can. All of everything I said and post and have online, it's all connected to him, to a trial, a divorce trial.
Right, it may be connected to a trial, but I do understand that. I understand what's in the background. That oftentimes most of my cases like this stem from child custody proceedings.
Well,
So
that should tell you something.
But what I'm saying to you is, but what I'm saying to you is that the emotional connection and the connection into what it does to you, that doesn't connect up your present bail condition to him being quote unquote a predator. There's not a logical connection between those two sentences.
Mm-hmm.
That you can't make that and so that's what I mean by you're stating things that are driven on your perspective and emotion. That's not something, and hear this clearly.
Well then,
you
will
never get to say to a jury. You can't say something just so broad and vague.
Right, but
that's not evident.
So they can get. This is how they get around that. Is instead of being the ones that send out the warrant, they have the other judge send out the warrant. That way, they're not named.
No, warrants and bail conditions are ordinary circumstance. That's not somebody trying to do anything weird. That's an ordinary circumstance in criminal proceedings.
Okay. Well, I think tomorrow morning is at 8:45, I believe.
Give me just one moment.
Okay.
Hold on.
Okay. Yeah, May 6th, 8:45. Trial is set Thursday, July 28th.
1 moment, please.
Oh, okay.
Can you hear me?
Yes.
I'm back.
Okay, 8:45, Friday, May 6th, omnibus hearing. Thursday, July 28th, 9:40 or 9:15. We have the jury trial.
Yeah, and as I said, I haven't looked at all of that. If there is a hearing, I'm likely to. I've got to see even what I can do tomorrow because I'm actually on the road right now. I won't have any connectivity for a little bit, and so if it says there's a hearing, show up for the hearing. But I likely am asking the court to move that hearing, whether it's in person or I may have to send something in ahead of time. I can't predict whether I can be there or not. I got to look at my schedule and what other things I have for that morning.
Okay.
But it's not going to go forward. It's not going to go forward in substance because it can't possibly. I don't have the information. And so, you
No,
know,
I agree with that.
you don't want to miss a court appearance. Yeah, you don't want to miss a court appearance so that they can revoke your bail or anything like that. So
Right.
you want to simply be there, you know, unless you hear from me. If I can hear something before that time of the morning, but it's also difficult with the Justice Board is that they are a little bit slow reacting to things.
I mean, is this gonna be? Go ahead.
Go ahead.
Is this gonna be a problem with
I just
Parker?
want you to. Is what going to be a problem?
Me being in the courthouse?
Well, has anybody told you you can't be, or is that?
Well, I have
What did anybody say about that?
I have a 1,500-foot no contact with Parker.
Okay, and no one spoke to you and told you what that means as far as court appearances.
No.
Okay, so you're telling me there's a conflict between what your bail conditions are and the expectation that you personally appear at that hearing.
Correct.
All right, I gotcha.
I mean,
I
I
understand that. This is what we're going to do.
Okay.
This is what we're going to do. I've been given a very late assignment with insufficient information to go forward on a substantive hearing. There is a legitimate issue. I'd assert that your question in that regard is legitimate, a legitimate concern to not violate those conditions.
Mm-hmm.
So don't show up. On advice of counsel, so if anyone at whatever point says, well, he wasn't there, you do get to say, Sam Harris said not to. Okay? I'll take responsibility for that. I'll file whatever motion we need to, make whatever kind of appearance we need to get on track. We'll seek clarification of such issues for future circumstances, you know, and we'll gather our information and we'll get started with the actual investigation, the bail issue that you have, all of those things,
Okay.
you know. But as we get started, I do want to tell you, I know you've got some strong opinions. You're going to have to let go of some opinions and listen.
Okay.
Or this is not going to go good for you. I can tell you that everyone I've ever had in these circumstances that holds on to these opinions strongly
Mm-hmm.
goes to jail.
Okay.
Goes to jail. I got one guy sitting in prison right now fighting the main allegations that are somewhat similar, but much more scary, but somewhat similar. And they got him in prison on the little stuff, waiting for the big stuff. They're going to fucking tag him.
Okay.
And he will not let go of what I would say is his rhetoric, the words he strings together. He won't let go long enough to even listen. And he's just never getting out. And so you have to listen, you know, and when we talk about things like if I say something that's logically connected, or you've got to stop using conclusion words because they don't work and they ruin your thinking.
Okay.
You know, pronouncing something a certain way, and we hold on to that once we've decided we think that, and then we can't hear what anyone else thinks about it. That's not going to work for you. That will fail 100% of the time, because any pieces of what you may have had to say that someone might hear, when you can't get past that one word and speak in a way they can see, and in their mind they think it's ridiculous, then they can't hear anything you say. And you honestly can't hear what they say. And in this type of circumstance, the one who loses if the communication is bad is you. And so you've got some of the things you've said already this morning, we're going to have trouble with. We're going to butt heads, you know, and you've got to hear it, or else it's going to go bad for you. You know, this is not a circumstance where you have an upper hand, and you do have something to lose, you know. So you now have a legal problem. Whatever else you had, you've got a legal problem that's of a criminal nature. You can't opt out of that. You have to go through it, whether you go through it in a good way or a bad way. But you have to get through this. And so then the question is, how big of a thing do we want to make it, and what does it consume of you? And
Right.
one of the things that I frequently find in cases like this is a person thinks, I'll make it real fucking big for everyone else. Ha ha ha! Only it doesn't, because no one else gives a shit. It's just work. They're just going to show up to work, going to do their job. I show up every day, I can do my job. Nobody can make it hard on me. It's just my job.
Right.
And so this is about what this does for you. And so I want you to recognize that real right off the bat, that you've got a problem to deal with, and you want to deal with it in the best way that you can. And I can tell you that the least likely way to be a good way, I'm not saying this for sure because I don't know yet, that the least likely way is jury trial. That's the least likely way for this to go good. Might be where you end up, but I always hesitate. I have many hundreds of clients that's their first position. Yep, jury trial, that's what we're doing. You know how many actually end up there? Very few. And of the ones that do, it's almost generally an awful goddamn mistake that they did. You know, and I'm not saying always, because, you know, sometimes the cases have a fact dispute, they need a trial. Sometimes the outcome determines that that's where we need to be.
Yeah.
But oftentimes, the reason we end up there is a failure to understand and a failure to communicate. You know, and so we want to think about what we've got. And so I want you to be ready to let go of prior held notions. And that's actually one of the jury instructions that the juries get. Let go of any preconceived notions. Base your opinions on what you hear here and what the law is.
Perfect. That's what I want.
We got to take a look at what our facts are. Got to take a look at what our facts are.
Yep.
Then we got to look at our defamation statute. We got to see how does this all fit in.
Yes.
You know, and then because the first hurdle is the state has to prove this. This isn't a civil case; it's a criminal case. So the state has the burden of proof. They have to prove that you committed the offense they say you committed.
Mm-hmm.
So we start with what the statute is. Then we take the facts that they allege and see if they fit into that. Then we take the facts that we think they can prove and see how that fits. Then we look at if there are facts we can prove that disprove that. But as I say that, I want you to let go of the idea that this is going to be about Judge Parker and that divorce proceeding. It is not.
No, it's not.
It is not.
Nope.
Be about that. Yeah.
Nope. This is
going to be.
This is about him and the continuing. That's it. It is what it is. We'll sit down and chat. So you say don't go tomorrow.
Yeah.
Don't go. Is what you're saying, correct, Sam?
I am saying that, and I'm saying that clearly.
Okay.
Because you're the one that's at risk, and I want to know as an attorney, I am making that representation to you, and I expect that if that goes badly, that you will say, he said that to me. So
right.
I'm saying that very clearly to you,
okay.
because I'm a man of my word. I'll stand up and take the heat for whatever happens if that's a miscommunication.
Okay.
But so I am saying that to you. You are being told by your attorney because of my late assignment, lack of notice, and a serious question as to the bail condition that I do think is a legitimate question for you to have.
Mm-hmm.
So I am giving you advice that says under those special circumstances, I would almost never say that. I would almost always tell you what I told you at first. You know you gotta go.
Right. Yeah, and I was ready to go.
You have raised a legitimate concern on that bail condition. And I don't want a miscommunication to result in for God's sake, what if Parker's walking in the front door at the same time as you are?
That's what I was worried about.
I just don't want that to happen. I don't want that to happen, and so I am saying that clearly. And if it goes bad for you, you do get to point at me and say, Sam said that. I was ready to go. I asked him a question, and he said that. Okay, so between you and me, we both agree that you get to point at me if that aspect goes bad, because I don't want that to go bad, and it won't. The court is pretty good with me, and I've worked with them all a long time, and so I don't expect that it would go south. But if it ever did, you do get to say, no, he clearly told me. Okay?
Yeah, because that's what.
I'm going to give you my email address. I'm going to lose signal in about 90 seconds.
Okay, go ahead.
I'm going to give you my email address. I took yours down, but I want you to shoot me an email.
Okay.
It's harrislawmt@gmail.
Okay, harrislawmt@gmail.
Yeah, shoot me an email just so I know we've got that contact. I work late at night, because I'm in court most of the day, and I happen to be moving today, so I just got out of court. I'm going to get a fucking U-Haul. Not a good day.
Okay.
But tonight I'll be back on, and I will get whatever documents of yours that they've got, so we have an immediate problem tomorrow. and I'll work that issue. So, you know, I will see that you've emailed me, and I'm really glad you called so that we can have these communications and we can get started. And you know, we'll address things as they come, but we'll get started. I know you're frustrated because you haven't had anybody for such a long time, and that's not appropriate either. That's not your fault.
Right.
That's the system right now.
Yeah.
But that's also why Melissa gave you to me. So I'll get right on it.
Okay.
You know, and we'll get it. We'll take a look at it.
Okay.
You know, we'll keep an open mind of what we got coming. You know, like I said, I don't even have all the facts.
Right.
I can't make conclusions.
Right.
I can say things that are guesses based on my experience, but I certainly can't conclude anything. So I haven't even seen the reports, and then you have a chance to sit down and tell me what there is from your perspective.
Right.
So we'll get a chance to do that. You know, I want to assure you, I don't make any final judgment. You know, anything that I say is based on my prior experience and the little bits and pieces I've seen.
Okay. Copy that. Well, I appreciate your chatting with me, and we'll chat.
Well, I'm glad to have direct contact, so we'll be in touch.
Okay, sounds good, Sam. Safe travels out there. We'll talk to you soon.
All right.
All right.
Thank you.
Yep.
See ya.
Yep. Bye bye.